Everyone is welcome here, it's time to make new friends. Aquavide Uskaba, fill your Glencairn. Share a dram with the spirit of Edmonton.
Luncha. Good day, Whiskey brothers, Whiskey sisters, Whiskey friends, and welcome to the Whiskey Book Club, 6th book of Season 3 with Brian Haara, author of this book right here, Bourbon Justice, How Whiskey Law Shaped America. And as always, I'm honored to have you, the viewer, with us here today, and especially this young man right over here with us. As a quick aside, I keep saying it, there are other Whiskey book clubs out there, but there's none that delve so deeply into the subject with the author like we do right here. My name's Dolph. I'm the Spirit of Edmonton on social media platforms. I'm the founder of the Whiskey Book Club. I'm your host tonight. Those of you that are new to the Whiskey Book Club, I'll tell you a little bit what we're about. We're a home base. We're a safe place for whiskey geeks that love to share a dram and their passion of reading, and usually about whiskey or whiskey-related activities. Brian, welcome. How are you? And what do you have in your glass tonight, kind sir?
Thank you, Dolph. Thanks for having me back. This first episode was great fun, and I'm happy to talk again about the rest of the book. In my glass tonight, I can be a value searcher a lot of the times, actually more often than not. So tonight I've just got it's about $28 here in Kentucky, an Elijah Craig small batch. I've got a locker full of barrel strengths Elijah Craigs and private selections, and I love those. But when it comes down to consistency, I don't want to be too much of a commercial here, but this is one of my go-tos.
And I have it and enjoy it myself. So good for you, kind sir. And I should say this is our 17th book that we've reviewed, and it's Brian's inaugural book. He's written. I think he's writing a second book now, but we'll find out later, maybe, possibly. He's done articles. He's a legal writer. He practices law at Tacomeek.
Yes, Tacomeek.
Tacomeek. I thought I was going to get it right. Business litigation firm. He writes about bourbon history, law on his blog, Sippin' Corn. So again, his blog, Sippin' Corn. And he was featured in that documentary, Straight Up Kentucky Bourbon. And if you look behind him to our right, his left, you're going to see there's the poster of it. So, and signed by a whole bunch of people. Tell me how many signatures or some notable signatures on that, Brian.
Well, one of my favorites up there is Bill Samuels, and he may be signed larger than a lot of the folks, so there's probably a good funny story behind that. Okay. But it's all the it's Jim Rutledge is up there, and it's just got. I look at that and see my own name up there, and it's a bit surreal for me because
surrounded by all these demigods in the bourbon industry, right?
Chris Morris is up there. I mean, he's one of my favorites, and then it's me. And
and you're worthy of being up there, sir. You are worthy.
Well, I appreciate that, but those guys are all in a totally different league, and it's for anyone who can get to a distillery and meet some of these folks. I really recommend it. Just listen to some of the stories. And it's you just soak it in. Just do what you can to soak it in, especially with the folks like Jimmy Russell and Jim Rutledge, who have been at it for so long. I mean, everything they say is a story.
And they would have my undivided attention for hours and hours.
Absolutely.
I would pour them anything continually just to keep hearing them night out. I'd take days and weeks off of work just to listen, I think. Mm-hmm. If I could keep up, I think. What I have in my glass tonight is, I told you this before, it's the Old Forester 150th anniversary, and I got that from a buddy called Whiskey Ass. Here, I've got his thing there. Gotta give him a little promotion. He got it, and I told you this before, at Wine and Beyond here, which is like Total Wine for you. You do have Total Wine where you are, right?
We do, yep. Only a few years. It only arrived a few years ago, but it's definitely here.
Okay. We've had Wine and Beyond, I think, for 10, 12 years here. They've been here for a while. And to get the big bottles, you have to go into a draw. And his name was picked, and he picked this, and he shared this amongst his friends. He kept a little bit for himself, and he did a nice label. Like, he spent a little bit of time on that too, so he's pretty proud of it. So this is the night I decided to crack this open, and I still get a smoke and a little bit of ammonia, a matchstick ammonia on it. It's not dissipating, and that's
so unique for a bourbon.
Oh yeah.
And they, I think I haven't had that 150th. Wasn't able to get a bottle of it, but it was so much fanfare when it came out. And whenever Chris Morris is involved in a limited edition or anything like that, you know it's going to be a special edition.
All right. Well, I'm happy to have it. I still haven't tasted it yet. I'm going to do one taste, and then I'm going to ask the question. Just what? I don't know what the percentage is on that, but it's more than 50. Taste. I got to look that up. I'll look it up at one point, or my lovely wife will look it up. But I'm going to start like I always do with a quote. But I want to start with my favorite term in your whole book, and you have lots of terms. And I'm a teacher, and what we do as teachers, we usually have the vocabulary up front. We talk about the vocab, and then we delve into it. But I came up with this word puffery, and I'm not sure why I like it. Maybe I just like the way it sounds, puffery. But you define it like this. So essentially, puffing or puffery is an exaggerated or boastful advertising statement that requires no substantiation, and therefore no reasonable buyer would believe was true. And I was reading that, and I'm thinking, yes, that's true. And I think it's true in any realm, not just advertising. People, you can tell when they're exaggerating. But then I stuck on the one word, and I can support this wholeheartedly. But really only as long as we're able to define reasonable. And I posed this to you before. So does reasonable change over time? And if it does change over time as the customer gets more savvy, is it kind of a circular situation where you're puffing more because people understand more, and then you're allowed to get away with more puffery? Is it kind of like that, do you think?
It can be, and reasonableness is a standard that comes into play throughout the law. All different sorts of legal standards involve is whether or not someone was acting reasonably, whether someone reasonably anticipated something, whether they were reasonable in the way they were driving their car. Even, I mean, sometimes a negligence concept can get into, was it reasonable to be doing what you were doing when you were doing it? So it's a common thread throughout all different areas of the law, and no different here. It looks at what a sort of standard person would expect under the circumstances, and that absolutely changes over time, and it can even change within a specialty, within a question of the law like you have here. And I think maybe it could shift somewhat here, but I think that the constant here is that it would require intent to deceive to go beyond this concept of puffery. So that's probably the key to look at. Maybe puffery can change a little bit, but as soon as there's an intent to deceive, then that's when you cross the line. You're no longer in puffery, you're in fraud, you're in consumer fraud, you're misrepresenting what your product is. So maybe the other key to look at is whether or not it can be something that is measured or substantiated. So long as you're always saying things like, we're the best, or we use the best ingredients, that's really can't be measured so much.
All right. So vagueness is key here. And I wonder, does it change from state to state, or from maybe your focus audience to focus audience? A 50-year-old compared to a 20-year-old, when we're talking about bourbon, I think there's a big difference. And I'm wondering if it changes over a period of time, with age, with location. And would they get away with something? Let's say the general public where you are right now, they know their information in regards to bourbon.
Mhm.
But how about people in California? I don't think the average person in California knows the average amount that someone in Kentucky does. And I don't think a 20-year-old in California knows as much as a 50-year-old female, male bourbon lover. I don't think this happens. So I wonder how you change that, or how the perception changes, and does it with the court, or is
Well,
it
I
just
think what you might see is if you had a case with identical facts in California and Kentucky, and it related to some bourbon sort of in the weeds issue that maybe Kentuckians, let's just assume, know more than the average person in some other state, whether it's California or pick Hawaii, maybe.
okay?
I
We're
don't know
not going
who
to
has,
pick on the poor California. Let's
yeah,
go
whoever
California,
has the least amount of bourbon knowledge.
Colorado. Oh, sure. Okay, let's just stay there. Or
So,
Canadians, because our bourbon knowledge is not up there. It
well,
really
there you
isn't.
go.
Scotch and Canadian whiskey, yeah, but bourbon knowledge, no. So Canadians.
So Canadians. So the interesting issue for me would be, would a court in Canada and would a court in Kentucky have the same standard? Now, I'm not aware of any case being brought that in two different jurisdictions at relatively the same time that have identical facts that you could measure that. So I think it may be an unanswerable question, but I think what your point raises is that the result could be different depending on where the lawsuit is filed, because the judge controlling the lawsuit may have less knowledge, the populace may have less knowledge, and then you're going to be relying on expert witness testimony that the distillery hires or that the plaintiff hires, who has done market research essentially into what the perception is of the words that are used. This happens a lot in trademark cases when you're looking for consumer confusion. The two brands at issue will each hire their own flock of expert witnesses who've all done their consumer analysis, and you do that through those questions. You either answer in person or answer online or answer on your phone, and they try to measure the amount of consumer confusion. And I think your audience is going to matter for that. And I think these marketing companies know enough to take a broad enough database to get the best sort of opinion that they can.
All right. Well, it is going to change. And I'm going to agree completely. You don't have the same facts in both cases, in two places, the exact same case. And it's too bad, because I can assume that I'm right, that it's going to change, but I would like to know for sure. And although I would like to know this, and I don't know who could actually answer this, who does have the greatest base knowledge when it comes to bourbon? Let's assume it's Kentucky. But I'm sure there's states around you maybe that might dispute it a little bit. I still would like to know kind of what an average is and how people would figure out kind of an average base of knowledge. That'd be neat.
I would be really intrigued. I'd be intrigued to see that. It could be Kentucky, but certainly Tennessee would lay claim to having experienced folks. But it might come down to between this cross border rivalry.
Okay, I like that. I like pushing the buttons a little bit. Just
right.
Let's go on. But I'm going to stick with the terms too, because I had a second term that I liked a lot as well, and I was taken with unclean hands. Just the vision and picture of it. So the unclean hands. So can you define this for our viewers? You do in the book. So if they want to see it in the book and defined over several pages, go back there. But perhaps referencing to the good and bad of puffery as well. So we're going to link puffery from Gaines versus Tucker, or any other case that you think is most appropriate. But
So unclean hands is a great concept. Some judges, some courts use the phrase clean hands. It just means the other side of the coin, but they're talking about the same thing. Now we'll get slightly into the weeds a little bit. When you sue somebody, pardon me?
No, that's good. Into the weeds we go.
Good. In the weeds we go. So in a civil court, as opposed to criminal court where someone's going to jail, a civil court is where one person sues another person, or person sues a company. for monetary damages because they've either violated a statute or they breached a contract or they were negligent somehow or another.
Okay.
Most all of those claims involve monetary damages. There's also something within that subset of civil courts called equitable relief. So that is when you're not asking for money, you are asking for the court to do something out of fairness, and you're asking the court to tell the bad guy that it has to stop doing something.
Pull all the bottles that have Crown Royal bourbon mash on it.
That's exactly right.
Okay,
that's exactly right. Take those off the shelf, or if there's an infringement on a trademark, take those off the shelf. Make that company stop using that trademark. That's equitable relief. So when you sue somebody and you ask for equitable relief, you're asking the court to do something out of fairness. So as a basic rule of fairness, the court will look into whether or not you have been fair. Have you been equitable? Have you acted right? And if you didn't, you're not going to be able to recover the equitable relief. You still might be able to sue for monetary damages if they've been negligent, if they've breached a contract, if they've infringed on a trademark. You still might get monetary damages if you can prove that you were damaged. But if you come in having done something unfairly yourself, you're not going to get relief.
And I really like it because you can't hold the moral high ground if you've destroyed your own basis of that moral high ground itself.
That's exactly right.
You can't stand upon something that you don't have. I love it.
Yep.
And with that case, did you want to talk about that case?
Sure. It was an interesting case to me because the court held that the defendant brand, which was called Golden Heritage, used the same sort of lettering, looked exactly like the word, the script being used for the word hermitage.
Yeah,
and it really does. You look at those, perfect. Yeah, if you can pull to that page. Right.
Can you see that?
Yeah.
Okay.
Now, those are obviously two different words, hermitage and golden heritage. But if you look at the way the H is done, you look at the AGE at the end, it's identical. And the court said, yeah, there is no doubt that Golden Heritage is coming along and wants someone to take a quick look and think that they're getting Hermitage. And they walk away with Golden Heritage when they meant to get Hermitage. So you're tricking the consumer with that. Now, it turns out in that case, so this is the perfect example, I think, of this concept of unclean hands. Hermitage sues Golden Heritage and asks the judge to stop them from being able to use Golden Heritage, issue an injunction. That's what it's called. And the court agreed that the lettering looked the same, that's exactly what Golden Heritage was trying to do. But guess what? Hermitage was not being truthful on its own label. It said things like, our bourbon is made over an open fire because that's the way they used to do it. In a pot still and all these sorts of things, when in fact the Hermitage was producing its bourbon in a column still, which was relatively new at the time, but it's called a continuous still, a column still. It's not that pot-shaped still that once you get all of the alcohol out, you then have to take the spent slop out, rinse it out, and then start all over again. A continuous still, as I think a lot of your viewers are going to know, like the name implies, you just keep running the thing. And it's a lot more efficient. You run it all day and you get alcohol all day. And that's how Hermitage was actually making its bourbon, not through an open fire with a pot still. So the court ended up holding.
There was more to it than that too. I think you had like 3 or 4 different things that they listed that were completely wrong. Yeah.
Right. So they didn't come, like you say, they didn't come in fairly and, as the court say, with clean hands. They weren't acting in good faith on their own label. And it's sort of like a mother addressing a squabble between 2 of her kids. If the first one started the fight or if the first one was being a jerk, guess what? Yeah, you're not going to be able to
punched in the mouth. Yeah.
That's right. That's why you got punched. Learn not to be a jerk to your brother and you won't get punched in the mouth.
Do you have kids?
I do.
Okay.
Fortunately, they haven't punched each other in the mouth.
No. Well, I had one incident with my daughters at one point in time. That was it. But and one really did deserve it. So it was good.
That's
so
right.
It was a perfect one.
Yeah.
Funny. All right, let's go into. I don't have a quote for this, but I'm trying to come to grips with. And as the book develops, we see the hero versus villain dichotomy. I think this comes across for me, and you bring it together at the end of the book. And I have other questions that's going to lead to this later, but it's in relation to the distillery owners. So I don't think that we should be espousing the grand humanistic nature of what they did, because their work, and we see how their work conditions and the products in the industry forced their hand to do things in a nice way. They were forced to be better people. So they were producers and dispensers of slop. So that was a big one. You talk about that. And they were responsible for, and you have lots of stories about the gruesome dismemberments, and it's usually within a dark warehouse, or someone brand new to the job and they didn't know what they were doing. How do we progress from villain to hero in this scenario? And how did they really help workers or consumers? So I don't need you to tell me that they were a hero or villain, because we'll kind of get to that later. But how did being the villain help them become a hero for the worker and the consumer both?
Well,
I can do that. That's a long one. I'm sorry.
Sure. No, it's a great question. And because it brings in a concept of the law that I think a lot of people bristle at, and maybe sometimes don't see the value of the law on this front, or it's perfect fodder for jokes about attorneys, because people have made fun out of the McDonald's case where they got sued because the coffee was too hot and it spilled on someone's lap and burned their lap. I mean, it's tragic, right? But I think everyone in the world thinks, of course, coffee is hot. Don't try to balance it in your lap, dummy.
Yes.
And we know, without having a label on our new toaster that we get, we know not to use our toaster in the bathtub, right?
Yes.
And we would make fun of whichever plaintiff's attorney was hired to file a case that said, this toaster was missing a warning label to say not use it in the tub. So my client got in the tub and wanted toast and electrocuted themselves.
Yeah.
So it's fantastic material to make fun of lawyers for this sort of thing. But those, I think, are just around the edges. What people don't see is the day in and the day out of lawyers making products safer and making working conditions safer, because they've brought these lawsuits. Now, some I'll acknowledge go far overboard, and I think we're now in a culture where there's probably too much warning. And I think some trouble with too much warning is none of it makes sense anymore, or you just don't read the warnings. I mean, how many times have you put something together? You've got a 17-page booklet, and the first 16 pages are warnings of what to do and what not to do. And then the last page is how to use the wrench to put it together. That's too much. So you're not going to read those, and you're not going to know what any of the dangers of the product are. So there are problems there. But the reality is that it's taken plaintiffs' attorneys in these lawsuits to give us safe working conditions and to give us safe products. And that's what I saw as I was researching for Bourbon Justice. That's exactly what happened. It took these sorts of lawsuits, a kid falling into a tank of scalding slop, and he burns himself. He's disfigured. Someone had to bring that lawsuit to get a safer working condition. Rotten rope and bad pulleys and barrels falling down in warehouses and crushing people to death, or flywheels pulling in someone's hand and taking your whole arm off, or worse. Those are bad things, but they weren't regulated, and unless the company got sued by either the injured person or the estate, and there was an attorney who was willing to do it, it's not going to change. So I think it's with that encouragement and with realizing the risk that they're creating and the damages that they can cause to a person and to a family. That's really what changes you from that laissez-faire, I can get away with whatever I can get away with attitude, which is where it definitely started, to something where you're leading the charge of safety, and you set a new standard that other companies then have to follow, or they're not going to be able to get the employees. If you have the safest workplace and pay the best, you'll probably get the employees. So it encourages everyone to be better.
However, I did feel sorry for a lot of these guys because they're that didn't get money whatsoever.
That's right.
If
so
it was nowadays, I'm pretty sure they would have gotten a lot. But
yeah, absolutely. And I think part of that is that it was so accepted at the time that warehouses were dangerous and that factories were dangerous, and there were different standards in place. There weren't safety laws in place. So now when a company violates those sort of safety standards or has an unsafe workplace, it's because they were reckless, or because they were intentionally cutting corners, or they weren't giving the training that they were supposed to. And I think that's maybe why you see now such larger awards. We've got a different mentality now. We've got different expectations. Back then, it was a free for all. People died doing all sorts of work at the time.
Sad, but really interesting. So you have to read this part. You really do. And but my heart did bleed for these people, and it's like, and they got nothing.
And they got nothing. That's right.
It's like, oh, really? Okay. I'm sticking on this vein a little bit. So let's talk about protection aspect of the Bottle and Bond Act, because when you're talking about distiller, talking to lawmaker, deciding upon this and pushing for it, I was thinking that I wanted to be in the room, and I know I'm being too simplistic, I'm being too flippant, but I'm picturing them in this room and one person saying, you know what, you protect my industry and you can tax us for the rest of everybody's life. Ad perpetua, you are going to get tax and tax and tax, but you've got to protect us. Get rid of the column stills, or no, not get rid of the column stills. Make a differentiation between the column stills and us, and make sure people know it. And I'm wondering if you know anything else within that, kind of the to and fro, the polling and the non-polling, and were they both very much open to the idea?
Yeah, it's a great example to use with that, because we've all heard stories about Colonel E.H. Taylor being the main proponent of the Bottled and Bond Act. He was connected with politicians, members of Congress. His buddy Carlisle was Secretary of Treasury at the time. That's who really helped him push through the Bottled and Bond Act. But I think we can also assume that there probably was not an altruistic bone in Colonel Taylor's body. He was absolutely a cutthroat businessman. He defrauded people when it benefited him. He probably was not a good guy. And now in history, we look at him, people call him the father of the modern bourbon industry, and they praise him for his leadership in the Bottled and Bond Act. Exactly. Yeah. And the Bottled and Bond Act was the United States' first consumer protection law. So here we are in a time frame, 1897, where you have slaughterhouses that are packaging rotten meat, or they're adding formaldehyde to it to preserve it, or you don't know what
coloring. Yeah,
coloring. You don't know what's going into the meat because they're trying to preserve it, and they're grinding up beaks, and you just don't know what's going in. As you get the saying now, how they make the sausage. You don't want to see it. Milk at the time frame was just as bad. Milk was hard to preserve. You needed to get it to market right away, but you got a good price for it at market. So when the price is that good, you need to find a way to preserve it to be able to sell it. So you add things again like formaldehyde, or it's such a good price that you want to water it down to make it go farther. Then you quickly realize, well, that's too thin. I mean, back then you're not talking 2% milk or skim milk. You're talking milk. So it's got to be
3.5 and 5, and
So you start adding thickeners to it after you've watered it down, and that can be chalk or it can be glue or something to make it thicker. And our federal government didn't do anything to protect consumers from those kinds of actions. And instead, the first thing that our government protected us from was rectified whiskey, from whiskey makers who were using the word whiskey in name only, but they were essentially taking grain neutral spirits, adding some color. Sometimes the color additives were safe, sometimes they weren't. Adding flavoring additives, sometimes those were safe, sometimes they weren't. You hear stories of if the whiskey wasn't dark enough, they would add, they would pick up the spittoon to make it darker. So they're adding things like tobacco spit to it to give it that color. But there was no regulation on it. And there was no protection from the federal government on it. And so what I suspect happened, if you and I were flies on the wall back then, E.H. Taylor hatched a plan to protect his industry being the producers of straight bourbon whiskey, to protect them against the rectifiers who could sell a product at a lower price that could most of the time fool people into thinking that it really was whiskey. So he gets this protectionism and he goes in under the guise of consumer protection, because you can't sell that to Congress. You can't say, I want my industry protected from those guys who make a quicker, cheaper product. You got to have a different theory. So it's consumer protection.
Okay. So you didn't think it was a pushing for taxes and then going to make money forever and ever and ever and ever.
Well, but Carlyle has to have some way to sell it too, other than just consumer protection, because that's all well and good, and you can go back and tell your constituents that we're protecting you from bad whiskey. But
give me more.
So we've got the Secretary of the Treasury with Carlyle. He's maybe doesn't have so much of an interest in protectionism or consumer protection and letting these members of Congress go back to tell their constituents how good they are for protecting them. He wants the money. So what's this going to mean? Now, whiskey had already been taxed. And in fact, whiskey had paid for every war that the United States ever fought. So beginning with the Revolutionary War, whiskey taxes paid for it. Every war they fought after the Revolutionary War was paid for by whiskey. So the concept of being in bond, in a bonded warehouse, was nothing new at the time. But what the Bottled in Bond Act did is it tied the two together. It didn't tax, it gave producers basically a tax freedom for 4 years. And it would only tax the producer on a certain volume of the barrels, because it would assume that there would be some loss to evaporation.
Angel share.
The angel share, that's right. And so it deferred that taxation. So E.H. Taylor could sell it to the other distillers, because you're saving some time on when you have to pay the taxes, and you're acknowledging that some of it's going to evaporate and you don't want to pay taxes on something that's lost. And the government gets its tax. So politics is a messy business, and the Bottled in Bond Act, I think, shows it.
But let's just say 3 different groups did well with it. The federal government did, and the distillers, the bourbon distillers, the pot still bourbon distillers did, and they are protecting, because when you're looking for a bottle, I like seeing Bottled in Bond. I do. And you also make a comment before, it's not a statement of quality. It's a statement of, what do you say? It's not a statement of quality. It's a statement of, I'm trying to remember. It'll come to me.
It was an issue of purity. So it's more purity than quality.
Okay.
Yep. Because
I'm
the argument
your exact words, because I liked your exact words before. It'll come up. I'll remember.
Yeah.
But I'm going to actually, no, let's clarify one thing before I get on to our presidents. You also said that for the taxes, it went up to 6 years and 8 years, I think, as well, that they had the tax break.
Yep.
What made that happen? Was it just a little bit more, they wanted more of a tax break and just asked for it, or just more public pressure? Or was there something that kind of let them get the extra 2 and then another 2 after?
Yeah, the bonding period shifted throughout time, and sometimes it had, and there were different proponents of shortening the bonded period and getting, because that would essentially get the market out, the bourbon out to market quicker.
Yeah.
So it all depended on how you viewed the market and whether or not having 8 years for the bonded period reduced the amount of bourbon that would be in the market for 6 years until things started coming out. But what distillers would do is they would completely wait until that time period expired before they sold and bottled any of the bourbon, because why not take the full tax advantage that you can? So they would do that.
Still good for us because we get really good 6 year
because we get really good bourbon.
We're happy. Yeah,
that's exactly right. But it can create supply and demand issues depending on how long that is, or if you have too much aging bourbon and there's more producers coming online, then maybe you can end up with a glut. And some of the smarter producers, more the business-minded producers like E.H. Taylor, was keeping a really close eye on the bonding period, and he was actually arguing for a lower bonding period because he saw that what would happen if there was a glut. He would know that the prices would go down for everyone, and in fact it was, because he was arguing for it. Everybody else wanted it longer. Unfortunately for him and others, he ended up being right, and there was a crash in the market that he predicted
during his time.
During his time, yeah.
Okay.
After the Bottle and Bond Act, more in the early 1900s.
All right, excellent. Thank you very much. And let's get on to the presidents, because I asked you this last week, and because I want to lighten things up a bit. You name the 3 presidents that you think had the greatest mark on modern bourbon industry. You gave us Taft. Well, you told us last week about Washington. You gave us Taft with the Taft decision. We talked about that a little bit. But I need to hear about Grover Cleveland, because you mentioned Grover Cleveland as being different from mine, but I didn't see his name, or I didn't remark it in the final 5 chapters, and I thought I was going to find it there. So tell us about Grover Cleveland. Why is he one of your top 3, sir?
Sure. He didn't make the book at all. You didn't mess him.
Okay.
So he's not in there, but he was the president who signed into law the Bottle and Bond Act. I think toward the end of his second term, non-consecutive term, I think it must have been. But he's also one of my top 3, not only for the Bottle and Bond Act, but because he was what's called a bourbon Democrat. And the phrase bourbon Democrat was actually a name that was invented by his political opponents, and it was meant to be disparaging. It was meant to be pejorative. And he's one of those guys somehow that turns an insult around, and suddenly it was good to be a bourbon Democrat. It was a badge of honor, of pride to be a bourbon Democrat. Now, bourbon Democrats weren't just from Kentucky. They weren't just from the South. They weren't from whiskey producing states. It was this odd alliance of Northerners and Southerners who opposed what I think today would be called globalism and imperialism. Okay. And they wanted more austerity measures. They wanted to end trade protectionism, which really resulted in high tariffs. And they were the outliers. That's not really where the country was going at the time. So he's one of my top 3, not only for Bottle and Bond, but because he was a bourbon Democrat. And I think that's a great phrase. And I appreciate the guy who's kind of fighting against the current from everyone else.
No, I do like that too.
Yeah,
the lone wolf, maybe, but he wasn't
a lone wolf.
He did become president, so he's not a lone wolf.
Right.
He's got a pack behind him. He's doing
right.
But I will look this up. A bourbon Democrat. I got to do that. But I am going to go on to Duffy because I thought he was funny. I liked your portrayal of him. I don't know if it was supposed to show him as how I took it, but I have an image in my mind of Duffy. So let's put on this quote right here. Boop. All right. Duffy's transgressions led to passage of the Pure Food and Drug Act and helped foster an atmosphere in false health claims, while still made today, will lead to legal liability. And he's just the snake oil guy, the guy that's going to say anything to sell anything. And I like a point of morality, but when it goes so far in the other direction, I find it comical, and that's where I get him, and that's where I'm picturing him from your description of him. So this very well may be the case on labels, though, but I'm thinking about the people watching TV at 2 and 3 o'clock in the morning, and they're saying this, you take this krill, whatever, and it's going to up your libido for whatever else. And they'll sell anything with these things. So I'm wondering if TV's one, which it's not the label. The label and TV are obviously two very different things. But I'm wondering if there are other areas that elude the majority of the regulatory bodies and possibly cheapen our beloved whiskeys by enabling distillers to convince us, stretch the truth somehow. So other than TV.
Sure. Well, other than the dreaded infomercial, because I think you're right. If it's 3 a.m. and you can't sleep and you're watching TV, you may be susceptible. Duffy is a great story, and I'm glad you enjoyed him too. He did so well with selling snake oil. A lot of people don't know this. He ended up buying what is now Buffalo Trace. So he bought the OFC / George T. Stagg distillery. And then next to it, also at one time owned by Colonel E.H. Taylor, was the Carlisle. So they were on the same property. Stagg died, and it was either right before Stagg died, he started selling some shares to Duffy, or it was after he died and his estate sold it. But one way or another, Duffy became an owner of 2 legendary Kentucky distilleries. And he and E.H. Taylor.
I thought they didn't like each other, so I didn't know if he would have sold it to him, or maybe
Stagg and his estate were more business minded. Now he did not get along with E.H. Taylor at all. And in my research, I've found letters back between the two of them, and they were as mortal enemies as Taylor and Stagg were. But at least Taylor and Stagg were both straight bourbon guys. They weren't this fake medicinal claim type situation. But I think opportunities are pretty small to elude the regulations, because now whiskey is so heavily regulated. And I think probably arguably over-regulated. There's still things around the edges, like use of the term small batch. That's not regulated, that has no definition whatsoever, and it can mean something different from one distiller to the next.
And you meant single barrel from the last time. That was my favorite one.
That's right. But if you see something that says small batch coming from a place like Jim Beam versus small batch coming from a craft distiller who can only
Copperworks, something like that.
That's right. It means 2 totally different things, and there's no regulation about that. But it's so heavily regulated that when it comes to things like what Duffy was saying at the time, I don't think we're going to run into. Now the labeling regulations even are so long. I mean, they're hard to get through. But nothing that Duffy was doing could happen today. Now you're just seeing things around the edges again, like small batch, or like Maker's Mark was sued for saying it was handmade. Those are the sorts of things that people are going to fight about now. And I know we've got a couple of other things to talk about that'll fit into this conversation. So I'll put an asterisk on this, and we'll come back to it.
All right, a little pin in that for now. Okay, no, that's good. We talked about Prohibition, so in the first week, and that this book was not devoted to it or revolving around Prohibition itself. We also stated that you could not get away with not referring to Prohibition, and then you finally do in here. And I'm going to do so again. I'm going to ask you to tell us about substantive law during Prohibition. So the development of what you call substantive law. So the removal of biased judges, which in the first, right at the very beginning, the introduction last or 2 weeks ago, where the sale and purchase of the item takes place, and interstate commerce. And all three of these items came as a result of Prohibition. And am I missing something? These three specifically, which is funny that it's funny in the situation that Prohibition was revoked, and you think of it as kind of a dead subject. Kind of, it comes up in well, especially in liquor, when you're referred back to it as kind of the days of the machismo, of the guys going back and forth over the Great Lakes and selling the bootlegging, and it's fun, but it's not thought of as a lasting law, something that lasts. You think of it as dead in that issue, and that everything changed, and you showed us three things that changed because of it, and not just then, much in the future. So am I missing anything other than biased judges, where the sale place and where you're buying it, because there's two different items there, and which was kind of neat to think of that, and the interstate commerce. So am I missing anything?
I would say one more would be illegal searches and seizures. Now, that didn't come out of Prohibition. That existed beforehand, but it was a huge factor during Prohibition. And Kentucky's case that essentially set our own state rule for illegal searches and seizures was a Prohibition era case, and that made it 40 years or whatever it was before the United States Supreme Court issued its seminal decision. It's called Mapp v. Ohio. That's the U.S. Supreme Court case on illegal searches and seizures. And Kentucky's law on that developed long before the U.S. Supreme Court because of Prohibition. It involved the Wathen family, and it involved a Prohibition agent just walking through the woods one day and saw, just look what I happened to see. And it looks like that shed has some slop coming out from under it, and let's look inside, and sure enough, there's an illegal still owned by a member of the Wathen family. They couldn't use it, so maybe he was illegally distilling during Prohibition, but it set the rule that you got to go out and you got to get a warrant. You got to be on the property, you got to be in the building with permission from the court to do it, or you're not going to be able to use that sort of evidence. So I thought that was really exciting when I found that Wathen case.
And it was interesting. And help me out with the sale and purchase of items as well, because that's not really clear. Something that is, it's legal in one state, not legal in the other. They buy it in one, and maybe they bought it in the legal state, obviously.
Sure.
Or their home state. Vice versa.
And before Prohibition, that actually was one of the main issues in Kentucky cases, because before Prohibition was enacted, and when Prohibition was enacted in the states, it applied to all of the states. But most states pre-Prohibition had their own either constitutional amendments or their own laws that allowed the state's counties on a county by county basis to decide whether or not they would be wet or dry. And Kentucky did that through its constitution. So a Kentucky county could decide whether or not to be dry or wet. So you could have the way the issue comes up is if you've got a traveling salesman who is bringing samples of whiskey, and you bring it to a dry county, can someone in that county buy there on the spot from the local salesman? And the answer to that's going to be no, because that's a transaction that is taking place in that county. But what if the person from that county buys from the distillery, so let's say Nelson County, that's where Bardstown is, and has it shipped to them? Is that allowable? Now, in law school, we spent an inordinate amount of time learning the law and the rules on where a contract is entered into. And it becomes important for all sorts of different situations, least of which I found out was bourbon. So when you a lot of contracts now will say this contract is entered into in Kentucky, and we apply Kentucky law. And if you're going to sue over it, it's got to happen in Louisville, Kentucky. Contracts didn't say that then, if there was a contract in the first place. So we learn all these factors that you look at as to where the contract was actually entered into. And so Kentucky cases, because of individual counties becoming dry versus wet, had to look at where the contract was entered into. And for these cases, the courts held it was in the county where the distillery was, and you could go ahead and ship it. So I thought that was really interesting.
And going over a different state, let's say 2 states were wet states or wet counties. The person who bought it was from a wet state, and the distillery itself in a wet state, and it crosses a state that is dry, a county that's dry, with a sheriff that wants to make a name for himself. He could stop that transaction, and he possibly could, I don't know, he could stall things and make a name for himself, or try to actually abscond with all of the bourbon himself.
That's exactly right. And that actually happened during Prohibition, when I forget now whether it was Old Crow or Old Taylor was being, for medicinal purposes, air quotes again, for medicinal purposes, was being shipped by rail from Kentucky to California. And the tracks that it had to go down to do that went through Georgia. And Georgia, in a particular county with a particular sheriff, was particularly militant in support of Prohibition. And this sheriff didn't even want whiskey to be traveling through his county. So he stops the damn train, unloads the whiskey, and is going to destroy it all when the producers and the purchaser run to court. And to harken back to what we said 30 minutes ago, they ask for equitable relief. They're not asking for damages. They're asking for an order that says, Judge, stop this sheriff from dumping our whiskey, from destroying our whiskey. They need that equitable relief. And the court ends up ruling that no, the Prohibition statutes, the Volstead Act, allows for medicinal whiskey. That's perfectly fine to buy and sell medicinal whiskey. You got to get it from point A to point B. You got to allow it through your state.
And it being a train, would that not have added? So we've got Via Rail, we've got CN Rail, and they're national, and they control an inordinate amount of land throughout our country. Now, I don't know if the rail lines themselves all belong to these 2 train companies or not, but I'm wondering if that happens there. So I was wondering if it's a national railway, obviously, and it's going across several states. Would that not have been a federal law? Could I call it federal law?
Yes, and so it was it's exactly right. What this case illustrated was a conflict between what state and local authorities wanted to do versus the federal law, which absolutely allowed the transport of medicinal whiskey. It allowed the purchase and sale of medicinal whiskey. And you've got interstate commerce implications because you're going from Kentucky to California and you're going through Georgia. So you've got all of these things that implicate federal law. And there is always a conflict between states' rights and federal law and which one applies. So it's the case gets really deep. Talk about in the weeds. That case in particular gets into some really heavy states versus federal issues.
I thought it was kind of cool because
I enjoyed it.
And it's in the book, obviously. You thought so too, but it stopped. And I had other questions, and I don't want to make this all about that. But it really did. It piqued my interest because there was so many different angles and so many things we could talk about. And right now, within our country, you can't cross provincial borders with alcohol. You can't. And through the states as well. And but alcohol is sent from one province to the other, and somehow it shows up. And often it's our Canada Post that's brings it from one province to the other, which is kind of neat. And they're turning a blind eye to it. Not just that, but I think drugs is a thing right now because legalized marijuana within our country. So I'm wondering if a lot of our legalized marijuana might be going still province to province and maybe down south. And it just evoked a lot of other thoughts.
Well, there are so many similarities. I mean, think back to what went on in Prohibition, the arguments that prohibitionists and temperance movement people were making about alcohol. The same arguments have been made for decades about marijuana. And I actually have a presentation that I'm doing in June. I'm paired up with a marijuana attorney. And we are going to talk about the similarities between the two. And I don't know what her part of the presentation is yet, but I'm going to just be so interested in what she has to say. I don't know that will have ever paid more attention to a co-presenter than I will to her, because I think there are these similarities, and I just really want to learn from her.
That might be another book too. Might be book number 2.
So.
All right, good for you.
Marijuana justice. Note,
I'm wondering, marijuana justice, bourbon, marijuana justice, and something. I don't know. We'll come up with the term.
Yeah,
I'll think of it too. Let's stick with that. We're good. I'm getting too far off. No, I'm not. I'm going to say it anyways because I wanted to. Why would you not have? Could you not teach a course? You go back to your alma mater, have one course. Maybe it could just be a prof brought in just for one single course, bourbon justice course. Would you be amenable to something like that? Is that kind of in the weeds for you? Maybe that one day.
It absolutely is. And I tried. One of the reasons I have so many footnotes in this book is I want it to be used in a college course. And I figured I needed to have a resource for every single factual statement that I made if it's going to make it there. And I'm just waiting, and I'm hoping that not only a judge cites my book as part of some decision. That hasn't happened yet, but I hope it happens. I've been mentioned in a few law journal articles, but I want that to happen, and I want a college course. And there's a school in Midway, Kentucky called Midway University. And they have some bourbon tourism courses. You can take several different bourbon classes there. And during COVID, I was brought in as a guest lecturer on Zoom for the class. And we talked about bourbon justice, and we talked about how to get a trademark, how to register your trademark, because a lot of the people who took this course someday want to make their own brand. So we talked about how to register a trademark. We talked about some of the risks on coming too close to someone else's registered mark or having that look and the feel of someone else's mark. And I would love to expand on that.
I think a guest professor touring the country. Maybe you're in a different state every year. It takes you 4.5 years to make your way through the United States, and then you can go to Hawaii because they don't know very much about bourbon. Maybe
that's right.
It's perfect.
That's right. They need to hire me for the full semester. I'll be in Hawaii for a half year.
And you know what? By that time, maybe you're on book number 2, book number 3, and maybe you'll be wanted. You know,
it's just a nonstop tour at that point.
Maybe by the time you're 60, you're completely retired, and you just they pay you ungodly amounts of money to come and present, and you're there.
You are articulating my dream, sir.
I wish you well, sir. I'm there. Let's get back to Prohibition, because I'm still and I talked about this before a bit, but it still has an effect on society, and I'm flabbergasted that it still does. And specifically, the case that used Prohibition disaster is what they called it, to suggest the need for continued regulation. So Maxwell's pick-pack. So they refer back to Prohibition. It's a disaster. It was horrible. But you know what? We need to do this anyways. They convinced themselves of it. So the most regulated of times, leading to a continuous of regulation to this day, it baffled me that it was still happening. Did it surprise you when he came across this case specifically?
Well, what surprised me is when I moved from Michigan to Kentucky. So in 1993, when I started law school, rented my apartment, move in, first night, I've got to fill the refrigerator. And as a, whatever I was, 22 or 23-year-old, what do I have to get the first night I'm there?
Beer and pizza.
Yeah, beer and pizza. So in Michigan, I could go to 7-Eleven and get beer. I could go to just a normal grocery store and pick up a bottle of whiskey. And I didn't know what whiskey was when I was in college. I would buy Southern Comfort, and I would probably tell you that it was bourbon. So you're young and dumb, all that stuff. But you'd also pick up a 12-pack of Milwaukee's Best Light for $4.99 and eat it with your bad pizza. So there's a pharmacy across the street. I walk across the street, and I was going to order a pizza and get beer there, and they didn't have beer. I had no idea when I moved to Kentucky in 1993 that I would not be able to walk into a pharmacy and get beer or get a bottle of booze. And so I drive, the main store was Kroger. So I go to Kroger's, and they have beer there for sure, but I couldn't buy a bottle of tequila or any sort of kind of liquor. Just baffled me, because just when you grow up and you see that there, I don't know that it's different in any other state, but it's totally different. So that was my first introduction to, okay, there's something different in Kentucky versus Michigan. Now, this Maxwell's pickpack case that you mentioned is out of Louisville. So it's a case that happened here. So I was able to follow it real time as it was happening. And I was aware, from having lived here for a decade or so at the time, that what Kroger does, what the main grocery store here does, is right next to the grocery part of the store, connected to it, but with a different doorway, it has its liquor store. So right next door, but it can't be in the grocery. You can go next door and you can buy the same beer that they've got in the grocery aisles, but you can also buy wine, and you can buy any kind of spirit that you want. So I had seen that sort of that difference existed. And so I was really interested when this case came out to actually learn why that difference existed. And as you say, it all dates back to Prohibition. It all dates back to this concept that spirits are a bad thing to have in the front of kids' faces. You don't want women and children who are, and I'm being sarcastic here, you don't want women and children at the grocery store to see spirits, because it's bad for them to even see it. I mean, that's the kind of paternalistic trouble we got into with Prohibition, and it's still alive. So whether you and your listeners are Star Wars fans or Harry Potter fans,
both
Prohibition's never died. It's it's Lord Voldemort. It's Palpatine. It's still there somehow, somewhere, surviving, and maybe someday we'll make a comeback. And I think we have to be vigilant against it, and vigilant against nanny states that control every aspect of what you can do and not do. And I think you see it coming through in the arguments that were made in this Maxwell's pickpack case.
And it happens here in Canada, same thing. I was born in Montreal. I was a child in Montreal. And I remember going to the corner store and buying my mother baby duck as a bottle for Christmas. Nice. I got in trouble, but I was able to buy this as a 4 or 5-year-old for my mother. It was $2. It was whatever. And then moved to Ontario in my teen years. And in Ontario, you couldn't buy beer and liquor at the same place. And they were not in stores. They weren't in the corner store like they were in Quebec. Mm-hmm. Quebec, very liberal society. Ontario, not at all. So things changed in Alberta when it became privatized, but it's still not sold in corner stores. You can't get it here in a corner store. You still have to go to a liquor store where you get beer and wine together. Right. So I don't think it's going to change. I think Prohibition did have an effect, and I really didn't think about how much until I was reading this. So it was really neat to kind of delve into this. So thank you for that.
Good.
And
Good.
yeah, and I'll keep my eye kind of with this, but I'm switching gears on you again. Here we go. The current this so I'm going to lead into the legality versus morality of two issues, and I like doing this with lawyers that I think have a moral side to them. So I want to see where you are on both of these issues. So first, we're going to hit with the secondary market, and then the second one, sourcing whiskey. And this is just a quote for you, just to kind of get the thoughts pumping. The current uncertainty is driven by distillation at undisclosed locations and bottling by entities pretending to be distillers in a seemingly limitless array of assumed names. And that was the sourcing whiskey part. So I'm just giving these two to you. Think about however, answer either of them, both of them, up to you. But where do you stand with the legality versus morality on both of those issues, please? And I'm going to start drinking bourbon mash from Crown Royal now. As you do that.
Fantastic!
This might be kind of amoral or illegal, but not moral. Anyways, I'll leave it.
Is that an original bottle, or does it have the disclaimer sticker that says this?
Oh no, this is original. This is right up.
Wow,
so
fantastic!
Yeah, it's great. Well, and it's half decent as a bottle as well. So.
Yeah. So I tend to agree that the case that you're referencing that I think you cited there involved a Northern Kentucky distillery, and they had a popular brand, and someone wanted to basically lease the distillery from them. And issue and produce their own brand, but it was really still the distiller who was doing it is more of this non-distiller producer thing that's so prevalent now. And the court said you can't do that. That's fraud. You can't just come in and change the name of the product. There's laws and regulations about having the distillery identified, and you can't just change the name for brands. I sort of wish that. Well, maybe I don't wish that was the law still. But I wish there was a law that required the disclosure of the DSP or the source of the bourbon, because I think more information for the consumer is better. And I think it would help drive the price down of some of these insanely priced bourbons that
if you knew it was coming from Indiana. Yeah.
Right, exactly. And so the state of distillation is usually on a bottle. So if it says Indiana, you know it's from MGP. But if it says Kentucky and you don't know whether this brand really has a distillery or not, it would be nice to see where it came from. And I think it would take the price down from these incredibly high prices, because essentially now you get a merchant bottler or a non-distiller producer who bottles whiskey from somewhere else. They'll charge you $150 for something that might very well be a $28 bottle from one of the main distilleries, and they're charging that much more. So I think for the consumer, it would be nice to know, wait a second, is this really an 8-year-old that I could get from on the primary brand for $28? Or is it that much better that I ought to be paying $150 for it? And I think the answer is going to be get the more reasonably priced brand. So morally, I wish I had that information. Legally, it's totally allowed now. You can be a merchant bottler, and unless you've got bottled in bond where you have to identify the DSP, you're really only disclosing the state of distillation. And if it's Kentucky, you've got a lot of options where it could come from. If it says distilled in Indiana, you pretty much know where it comes from. If it says distilled in Tennessee, you've got 2 options more or less that it's going to be having come from, but you don't know. And as a consumer, I'd like to know.
And labeling is a federal law. It's not state by state.
Well, there are some state laws. So for example, Kentucky has its own law that says if you have Kentucky on the label, You have to have been distilled here and aged here for a certain number of years. So there are some state laws, but you're absolutely right. The primary focus is federal law for that.
Okay. So did you have a problem when Whistle Pig comes out with their 10, 12-year-old and it was Alberta whiskey? Because we knew that it was our rye going to Whistle Pig, and it went from a $40 bottle to 120 Canadian. So I don't probably $20 American for you, but
that to me, I don't know all the details, but from what I have heard about that particular that phase of Whistle Pig's life, it's
early,
really shady. That you get Alberta, and I've had the Canadian edition of Alberta Premium, and it's fantastic. But it was probably $20 US, and if that's what's going into Whistle Pig for $250,
finished for an extra 6 months,
right? Right. Does that add the extra $230 US? I don't know.
Having said that, I don't want to poo-poo Whistle Pig because they want to be a sponsor of the show at one point. I don't want to push them away.
Right. No,
the 6-year-old I tried very recently when I was doing another book, and I really enjoyed it. Like the 6-year-old Whistle Pig, which is theirs, I believe, because they're producing their own whiskey now, and I believe the 6-year-old is all theirs. I liked it quite a bit, but I don't know if I like sourcing whiskey as much. I know it's legal, but I think if you're sourcing, I would love to see the information. And I think you referenced Bullet at the time as well in the book, and there was a couple others, but
it can be a lot of these merchant bottlers can be fantastic. On the bourbon front, Smooth Ambler sourced from MGP forever and had some absolutely fantastic whiskeys. And I think probably helped put MGP on the map. So when you know where it comes from, I think it's helpful. But when you have no idea where it comes from, and maybe it's Alberta Premium and they're charging $250 more than you could get for Alberta Premium, or maybe it's something from Sazerac that you could get for $30 here, and all of a sudden it's $150. I'd like to know that, but if
they do that in Scotland, like they address this in other places. So independent bottlers, and I have them, SMWS, but they'll say where it's coming from. It has to have the age on it, and you can promote it as a blend. You can promote it without a name, but people don't buy them as much. Well, in Scotch, if it's a single malt, people will have a hard time if it's a single malt blend purchasing something at a really high price if they don't know where it's coming from, or if the information's not online somehow. I'm just wondering how this hasn't really translated to the same kind of level in the States with bourbon. Or not just bourbon. Let's go all whiskey, because it's all whiskey. It's not just bourbon. I wonder why.
I wish I knew the answer to that. And it's just maybe it's Diageo not, and this is total guess, not wanting people to know that Bullet Rye was really MGP. It's a really good rye, and it's really popular. It's I think I prefer it more in a cocktail than I do neat, but it's a really well-selling rye, and it's really good.
Have you ever gone on their website? Because I've gone on the MGP website, and I'm thinking I would love to create my own barrel, and they will sell barrels or small quantities, not small barrels, but small quantities, and obviously large quantities. But they're transparent, and they do everything. They'll individualize what you want for you. They'll give you what you want, and I don't have a problem with people doing that either. But maybe they should state it's from this lovely place that maybe 30% of the whiskeys in the United States is actually sourcing from. I want the information. I do.
I do too. And Stephen on the comment says that sometimes the distillers won't tell you, and that's absolutely right.
Yeah.
There are confidentiality provisions in
Yeah.
most of these sourcing contracts. Distilleries who produce it don't want the consumer to know and don't want the independent merchant bottler to say where it comes from.
Just in case they do something that just doesn't stick with their brand name or something
that's right.
that tarnishes them.
That's right.
Yeah. But
so that means we can't find out.
Okay. I was talking about being surprised before, and your Jack Daniels versus Hoffman distilling ruling.
Mm-hmm.
That surprised me because you're leading me and the reader. You're reading, yeah, they're going to get it. They're going to get stuck. This and this and this and this and this. They're reading all these things they did wrong, all these similarities, but it didn't matter because in the end, it wasn't on the label.
Yeah,
right?
The feeling I had as I read that case was what I tried to bring the reader of Bourbon Justice down, because as I read the case, the court spelled it out sort of in that same order that I did. This part's similar. It lists off 10 different similarities. As I'm reading this case, they totally buried the lead because I'm reading it and thinking, yeah, this Ezra Brooks brand is dead in the water. Yeah. Absolutely dead. And you read 4 or 5 pages of the case, you're thinking that, and then all of a sudden you get the rug pulled out from under you. So I tried to do that same thing in the book, because I had that feeling of Ezra Brooks is dead in the water, and then all of a sudden they're not. And I think the key decision in that case was that it gave the consumer the slightest bit of responsibility to not be confused, to not be a dumbass, to be able to read that one of them is Kentucky straight bourbon whiskey and the other is Tennessee whiskey. That's really what I pulled out of that case, is that maybe the pendulum had swung too far to entertain how consumers might be confused. And this case finally came in and said, all right, it looks like the same damn thing, but listen, consumer, you've got to use your eyes. You've got to use your brain. If one says Kentucky straight bourbon whiskey and the other says Tennessee whiskey, it's something different.
Okay. And I can respect that, actually, because I want people to be a little bit more intelligent, a little bit more discerning, right?
I think that's a good goal. I think that's, if there's a public policy that can be made through the law, it's to give people a little more personal responsibility. I'm with you on that.
All right. And but talking about this, there's been tons of loopholes in the past, so many ways to manipulate the general public, that I'm wondering if there was ever a backlash, because I know the puffery.
Right.
And we talked about how it changes over time and people get smarter over time and they're able to discern what's right and wrong, what's puffery, what's not. But I'm wondering if anyone ever crossed the line, if they went so far that there was such a backlash that they had to reverse, do a full 180, a very quick one. So I think you're the guy to ask about that.
I think there is an example for that, and it's probably Templeton Rye, which, since we're on the subject of MGP, I think that
I've got Templeton Rye and I enjoy it.
It's a good segue. It's a good rye, and it was one of the, before MGP was well known as the merchant, the source for merchant bottlers. Templeton Rye out of Templeton, Iowa, had this fantastic marketing story of Prohibition era rye and Al Capone coming down to Iowa. And it's the same sort of thing that you talked about earlier about, glamorizing this era and the bootleggers. And Al Capone certainly has been glamorized beyond what I ever would have imagined of someone like him. But nevertheless, an Al Capone story makes a good story. And it was really MGP rye. And maybe Templeton did a little bit of something different to it, but it was MGP rye. And if you read the label, you really 100% believed that it was made in this little Iowa town and it was some special recipe that existed in Prohibition era.
Grandpa's grandpa.
Exactly. And it was all false. It was all a marketing story. And Templeton got sued in a class action complaint, and they ended up settling the case and putting all these I don't know if you call them safeguards, but they made all these changes. And now if you read the Templeton label, it doesn't make you believe that it was distilled under some old recipe from the Prohibition era in Iowa. It's got Indiana on it. It will tell you that it was distilled in Indiana. So I think that's a great example of having gone too far. Maybe people shouldn't believe.
How about people? How about, was there ever a backlash of people? Because that could have been one person, two people, a company, or a rival that might have brought that to court. But I'm wondering if there's thousands of people rallying against something, dumping out their rye, dumping out their Crown Royal bourbon mash somewhere. I'm wondering if there's a point in time where something like this happened. It was
where the people revolt
with their puffer.
Yeah.
Yes. Yes.
I don't know of a true people's revolt on this.
Right.
I'm trying to think if I could ever think of one. I mean, there's, I guess online you see people rejecting Pappy, which I think is a smart move, or at least rejecting what Pappy has become.
Let's just bring it down a little bit.
Yes, exactly. It's to rein it back in. It's to tell people, no, this is insane. This is not a $5,000 bottle of whiskey.
Yes.
Don't be stupid about things, people. So I think I've seen a Pappy revolt. I think I've seen a Blanton's revolt. I mean, people here, at least in Kentucky, they don't think Blanton's hung the moon anymore. And they think you're silly if you're trying to follow the truck to get to Total Wine because you think there's a Thursday morning delivery and you can get Blanton's. So thank God that's happening.
Well, having said that, I still bought the Blanton's Gold, but I paid $100 for it.
Yeah,
I didn't spend too much. I didn't feel too bad about it. But you know what? I think you're very right about the Pappies. I think that's kind of a people's revolt. It went too far. It wasn't because of puffery. Maybe it was just Bill Murray's Whiskey Bible and hyped it up from there and kept hyping it up. So I'm just hoping all whiskey prices kind of shrink a little bit, because it's getting a little bit out of my price range.
You and me both, and we're about to the phase, I think, where a lot of distilleries doubled their production capacity about 5-6 years ago. So we are about to the phase, I think, where there should be more 6 to 8 year bourbon hitting the market, which is a really nice sweet spot for a lot of brands.
Yeah,
they'll be able to age things to that next sort of level, which is the 10 to 12, and we should be having that in a few more years. And I am really hopeful that excess capacity will help bring down prices. Now the issue is, do these distilleries send it all to India and China, and then we're back in the same boat where we are, where there's just not enough here? That's unfortunately probably the more likely scenario.
Yeah, it's all going to China. Well, hopefully not. And Scotch, same thing. Price is just going way up the roof. A Dalmore 18, which is something that I found to be a very mediocre. Let's leave it at that. Mediocre, and it's selling for $600 for an 18-year-old, whereas I can get so many other 18-year-old scotches that are far superior. But you know what? Let's leave it at that. Let's say that's the line. Maybe the line is money. Maybe the line is money. Or an inflation of your own self-interest, and the average buyer not being able to partake because of that. Maybe that's it. Maybe that's the one.
That might be it. That might be the way to look at it.
Okay. And here I'm reading it. Be okay if happy if Buffalo Trace, Ryan again, Store Picker, maybe Eagle. I do like Eagle Rare at one point. Yeah. Let's do that. I want everything to go back to normal, whatever my normal is. My normal. All right. Another quote. And I haven't given you too many quotes tonight. I think this is only 3. It might be 4. Yeah, this is 4. Sorry. So, despite an overabundance of regulations and official guidance, there is plausible confusion around the edges. So, bourbon brands can find inventive ways to avoid being overly constrained by transparency. So, it seemed like you were giving them a little bit of leeway to stretch the truth a little bit, and I thought this was a way of saying that they're still very, I don't want to say very sneaky, that they're still being a little bit sneaky and manipulative. They are. They have that license, but it does feel like a game to me. It does feel like the more they get away with something, and they're being mischievous and cute, and I'm just a good old boy. I'm just trying to sell my stuff. You can't blame me for that type thing. And then, but it's a little bit in the face of purity and honesty. And when we talked about at the very beginning, I hadn't read the whole book yet because I always go section by section. The thing that I was really impressed at the beginning and the law was that it seemed wrong. The ruling went against somebody because it was just wrong. And now I don't know if there's that, it's just wrong anymore. It's like you get away with as much as you can. And it does seem like a game. And I don't want to lessen anything or anyone's legal system or promotion of goods, but do you feel like it's a game? You're trying to get away with as much as possible, and they fight back a bit, and you're trying more and fighting back. Does it feel like that to you? Or
Well, bourbon producers have always pushed the envelope.
Yeah,
and I know this will to non-attorneys and to non-tax accountants. This is what gives us a bad name. Absolutely. I accept it. I embrace it. But our job and the job of tax accountants is to see what the law allows. So if a tax accountant can tell a rich guy, let's move some money to Bermuda, or let's put it in this
Cayman
tax
Islands
haven.
somewhere.
Right. If that is allowed by the law, you might think that person is a cheat. You might think that person's not paying their fair share, which is the current popular thing to say here in the States. But if it's permitted by the law and you hire an accountant to make sure you're complying with the law, then frankly, I have a little bit of admiration. Now, I don't have that money to do that for me. It's not my issue. But frankly, I've got a little bit of admiration. And the law is pretty similar to that in that if you're representing a client who asks you, can I do X, Y, or Z, you must be a zealous advocate for that client. And maybe you only tell the client you can do X and Y, but not Z, but you got to go to that extent. You got to do it. And so long as you're within the law, as long as you're not helping to perpetrate fraud, as long as you're not finding some way to break the law and then get off the hook, then I do have some admiration for that. And that's part of, in bourbon history, that pushing of the envelope and testing the limits. I have some admiration for that too.
Okay. And you're allowed to, and there's nothing wrong with that. But it does it does feel like a game. It feels like, and maybe a game's the wrong way of putting it, but game is
a right mentality,
building up upon itself and
that's right,
changing.
I think the game analysis is right, because you're seeing how far you can go, and to some people it will seem like you're being unfair or cheating. And I'm a person of laws and rules. I respect them. I'm sort of the rule follower.
You should be. Yes.
Well, exactly. And I there are probably some accountants and some attorneys who will say, well, you're not going to get caught for that, so let's do it anyway. I don't ever want to be that guy. I want to say, this is what the law is. This is the extent that you can do something. Go ahead and push it to that extent, but I advise you to not go any further. And as long as that's legal, I don't think people ought to have a beef with it. What you ought to have a beef with is your legislatures who enact those laws, And if you want to change what's allowable or disallowable, go to them.
Talk to that. Yep. And I'm with that too. Power to the people and change it.
Yeah, that's right. You can change the law as the people.
Yeah. Put on your big girl pants, your big boy pants, get in there, get a little bit muddy and fix it. No,
that's right.
I'm good with that too. I'm good with that. I'm going to end this, but I'm going to do it like you did in your acknowledgments, because I found it way more entertaining than most. So thank you very much for the acknowledgments. I loved it. But you had so many people. I don't want to go through thank you to everybody, but I want to know who inspired you, who motivated you, and who sustained you, if that's okay.
Sure.
So those three, I think, who made you do this, who motivated you to do it, and who kept you going. And I'm guessing your wife is in there somewhere. So let's give her number one. And your wife, Laura?
She better be. I heard that in the background.
Laura? That's my wife, Laura,
yeah.
saying that.
Yeah. Okay. I thought it might have been someone on my shoulder saying that, but no.
That's okay. Yeah.
So I've mentioned him a few times tonight, but Chris Morris is probably one of the people who inspired me. He's the master distiller at Brown-Forman and therefore Woodford Reserve. And I had dinner with him before I wrote the book, when it was just as they say, a twinkle in my eye. And I had dinner with him at a sort of a destination bourbon bar in Louisville called Bourbon's Bistro. Okay. And when we got to the part of drinking bourbon, I told him, all right, I'm not going to get a Brown-Forman product, but I want you to taste this blind and I want you to tell me about it. And he was game for that. And I loved him for that, because I would think a lot of people in the industry only want to be seen drinking their own product. But we drank others than Brown-Forman, and he was game for it, and he was great. And he told me all about his investigation that he was doing at the old LeBrow and Graham Old Pepper Distillery. And he wanted to know more about James Pepper having to sue his own mother for control of the distillery. Mm-hmm. And it was a fantastic night, and I'll never forget it. And it was really a night that helped inspire me to look deeper into these lawsuits as a way of telling the stories. So I really owe a debt of gratitude to Chris Morris to helping inspire finding out these additional stories and using them as the backdrop for bourbon history. So Chris Morris, I will say cheers to any day of the week.
Cheers. And that's the inspired. So
that's the inspired. Motivation is and motivation and inspire probably are pretty similar. I was motivated a lot by other bourbon enthusiasts, whether it be folks on social media, people who I was meeting on private barrel selections, owners of small stores who had a vested interest in doing these barrel selections and getting the best selections for themselves. But really people who showed me that they were interested in it. If I didn't know people were interested in telling bourbon history from this standpoint, I don't think I'd be motivated to have written any of the blog entries or written the book. So,
or hearing about it.
Yeah. So I love knowing that the people were there, and I suppose some people might write something just for themselves, just to get something that's in their mind out. But I don't know that I would do it if it were just for me wanting to get something out of my head. I would want to know that people are actually out there who might want to hear about this, might want to learn about this, might want to talk about this. And if there's anything that I'll talk about, it's this. I mean, I love talking about bourbon history and old bourbon lawsuits, what I've learned about it. And I've continued to find people after writing the book, and as I've done corporate presentations and bourbon group, bourbon society presentations, people are really interested in this, and
guest lecturers throughout the country. Yeah, I got it.
It warms my cold heart. I mean, it's great. I love to talk about it. I love that people are interested in it, and that's a motivation. And then sustaining. This is where Laura comes in. This is where my wife comes in. She absolutely sustained me on this. I give her some grief sometimes because I think early on in this pursuit of mine, she probably rolled her eyes a little bit that, oh, he's going on another barrel selection, or he's writing this blog thing. But she absolutely sustained me through this and supported it and was my muse and is fully supportive. She actually went to the archives in Kentucky's capital of Frankfort to find some of these old cases for me and to find some of this deposition testimony and these exhibits that I refer to in the book, which was incredibly helpful. And I wouldn't have been able to do that on my own. So she sustained me and continues to. Is
she a lawyer as well?
She is. We met in law school. We were both the same year in law school. We were one of those I think it's probably pretty annoying to everyone else, but we were one of those law school couples. By the third year, we were taking most of our classes together and would sit next to each other. And I'm sure it annoyed a lot of people, but we had it made it a lot easier to get through.
That's right. Well, cheers to all the wife Lauras out there.
Absolutely.
Mine and yours.
Cheers.
Sustain us through these habits. And I haven't read a book yet, but maybe that's coming
one day, baby.
All right. Well, thank you. It's been a wonderful time, Whiskey brothers, sisters, friends. Fantastic evening. Thank you to our listeners who joined us today, and most of you who join us in the future. Special thanks again to this gentleman right here, Brian Haara. And with this book, there's the book. Looking forward to reading your second and possibly third book out there, sir, sometime soon. And I'll give you last comments before I do my last little spiel. Anything else you want to add in there?
I just really encourage people to share your whiskey, whether it's Scotch, Canadian whiskey, bourbon, rye, whatever it is, with your friends and your loved ones. It's not something to hide away and collect and put on an NFT and just never open. Bourbon and Scotch and rye, all whiskeys are meant to be shared with the people you love. Don't miss that chance at all.
Perfect sentiment.
Yes,
and my wife said in moderation. She's always like, no,
right, in moderation.
Not even in moderation. Sometimes, yes, or most of the time. And thank you again because you're talking about exactly what Kent, my buddy, did for me and giving me the Forester 150. This was 62.4% actually. And Stephen on the side shared his stuff with me before. It's the community that we love, and it really it makes me happy. It makes you feel like you're part of something. Thank you, sir. So good sentiment.
Thank you.
All right. So you know what? We'll see you all in 3 weeks' time, April 16th at 9 o'clock Mountain Standard Time, which is going to be 4 o'clock for our guest British summertime from England. And we'll be commencing our 18th book, this one right here, The Philosophy of Whiskey by Billy Abbott. This comes out in North America on May 1st, but we're going to talk about it on, 2 weeks, and starting the 16th, and then we're going to do the 30th. So it's going to be great. And if you want to get kind of a sneak peek into the book, join us and click like, click subscribe, come see us, join us. And kind sir, if you could hold up a glass, we already did for our wives, Laura, but we'll do it for everyone else now. Here's a good company. This gentleman right here, my wife over there. Here's the good whiskey. Here's the good conversation. And sláinte. And thank you to everybody out there. Have a fantastic night. Thank you, sir.
Cheers. Thank you. Appreciate it.